Hello everyone, welcome to Legal Darshan. In this video, we are going to discuss case number 31 in the list of AOR leading cases for the AOR examination 2025. The case is titled as Lalita Kumari versus State of UP and others, Government of UP and others. Now, in this case, basically, this is one of the landmark judgments we go running back to in the FIR, in the sections related to FIR. Now, the moot question in this case that is before the bench, before the constitutional bench, is the question that whether a police officer is bound to register an FIR upon receiving any information relating to commission of a cognizable offense under the then section 154 of CRPC, or the police officer has the power to conduct a preliminary inquiry in order to, or with the intention to, test the authenticity or test the veracity of the information that has been furnished before him. Right now, in the head notes, this question has been raised. So the question is here: the instant case were referred to the constitutional bench for deciding the question that whether police officer has to register the FIR mandatorily, or he has to investigate the veracity or authenticity of the offense that has been committed. Now, this case is one landmark case in the FIR jurisprudence, and it is holding that there is a use of word shall in the language of section 154 clause 1 of the CRPC. Okay, so we will come to the paragraph. Yes. So court herein is interpreting 154 clause 1. Okay, so now the court herein is saying, when we are talking of interpretation, that the term thereby used is the term shall, which is giving it a mandatory nature, right? So there is no ambiguity in the language of section 154.1 the court is holding, because a plain reading of section 154.1 is saying that if any information is given to a police officer in charge of a cognizable offense, then, or even if it is given orally, the police officer shall reduce it to writing. Either he will do it himself or under his direction. And the court herein is laying down that there is no ambiguity in the language of section 154. The court is also laying down the important condition for an FIR to be registered under Article 154 Clause 1, which is a sine qua non condition, which is an essential condition for recording of FIR under section 154, which is that there must be information. Number one, what we need is information. And number two, that information should relate to cognizable offense. Okay, that information should mandatorily relate to cognizable offense. If any information disclosing a cognizable offense is let down before an officer in charge of the police station, satisfying the requirement of 154.1, the police officer has no other option except to, record such kind of information and to deduce it in the writing in the prescribed format. So that which is, in other words, which is to say that he has to register the case on the base of the information that has been given to him. Okay, so now the court herein is saying that if the information given to him, if the information that he is receiving, that does not disclose a cognizable offense, but that discloses a need, a necessity for an inquiry to be done, then a preliminary inquiry may be conducted by the police officer, but only to the extent to recognize whether the offense done is cognizable or non-cognizable, right? So he can initiate the inquiry. The police if the information is given to him is revealing that there is a cognizable offense, he has to register the FIR mandatorily. But if the information received by him is not sufficient to, establish a cognizable offense, he may lead an inquiry into it. And if that inquiry concludes the commission of a cognizable offense, or if discloses the commission of a cognizable offense, then only the FIR can be registered. Okay, so in case there is no cognizable offense being committed, a closure report may be filed, right? Police officer cannot basically disclose his, his mandate under section 154 to, not register the complaint, because shall is the word that has been used here. Okay. So now for cognizable offenses, a duty has been casted on police officers, but it can go for investigation. It can go under section 157 of the CRPC code. Okay. So now herein the court is also saying that as to, how the preliminary inquiry has to be done. Okay, it has to be only done to the extent to identify whether a cognizable offense has been committed or non-cognizable offense has been committed. But it does not need to go into the veracity of the fact. It does not need to authenticate the information that has been received by him. All right, it depends on the facts and circumstances that how that inquiry will be carried forward. But the inquiry, even if the inquiry is being taken up by the police officer, because there is no disclosure of cognizable offense as per the information received by him, it should not exceed 7 days, right? And it should be done in a manner that it protects the interest of both the accused and both the and as well as the complainant. Now, it is also directed in the case of Lalita Kumari that there shall be the station diary or shall be the general diary in which all the information that has been received by the police officer that needs to be recorded, whether whether it results in an FIR that there is a prima facie cognizable offense, information is furnishing that there is a cognizable offense, then it can be deduced to an FIR. Or in case we need to do an inquiry, then for even in that case, that information must also be present in the station diary, and it should be reflecting in the diary that why a decision to conduct a preliminary inquiry has been taken up by the police officer. Okay. Now, the Lalita Kumari case, when it started, it is starting as that the father of Lalita Kumari is coming before the Supreme Court's Article 32 jurisdiction, which is basically against the denial of police officers to register an FIR. Okay. Now here the court is mandatorily saying that police officer cannot deny registering an FIR just on the ground that they are verifying the truth of the information received. Now, yes, court herein is saying that there are certain cases in which preliminary inquiry can be conducted if the information that is furnished is not leading to a cognizable offense. That could be conducted in some cases like family dispute, some commercial cases, some cases of medical negligence, some cases of cases where there is an abnormal delay in lodging of the complaint. Even in those in those, a preliminary inquiry can be done, right? Now, yes, so consciously the court, this paragraph I find important, the legislature is consciously using the term information in this section because it is not qualified by the prefix reasonable or sufficient or credible. Okay, it is not a qualifying information, but rather any information. So the purpose here is that any kind of information that is brought before the police officer, that is need to be registered, and it is not based upon his subjective test of reasonability or credibility, right? It is not required that the information that is given to him is reasonable or credible, but rather any piece of information that is being received, if it is enough to establish a cognizable offense, the FIR must be registered on the said ground. So this was it, which was held in the case of Lalita Kumari versus State of UP. It's a constitutional bench judgment, and since there was a regular denial of registration of FIR, this case has been taken up by the Supreme Court, and the discussion herein was the finding of the Supreme Court. Now, this judgment is basically ensuring prompt registration of offences, and it is also putting a check on the arbitrary power of the police to, delay or deny the registration of FIR. It is basically bringing the access to criminal justice to the victims of crime, also promoting accountability, also promoting transparency. But now, since we have we have undergone a criminal law overhaul. The section 154 of the CRPC is now replaced by section 173 of the BNSS. Now BNSS, herein when we come to clause 173 clause 3, the same thing that has been said in the case of Lalita Kumari, that there cannot be any preliminary inquiry so as to ascertain the veracity of facts. It is something similar to that finding is led in section 173 clause 3. So section 173 clause 3 is reading that without prejudice to the provisions contained in section 175 on receipt of information relating to commission of any cognizable offense which is made punishable for 3 years or more but less than 7 years, the officer in charge of the police station may, with the prior permission from an officer not below the rank of deputy superintendent of police, considering the nature and gravity of the offense, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within the period of 14 days, or proceed with the investigation when there is a prima facie case. So partial overruling of or partial overriding of Lalita Kumari judgment can be found in this place, because herein we are going for authenticating of a prima facie case. We are basically looking into the veracity of facts, which is not something as said by the Lalita Kumari judgment. Since there is a criminal overhaul, the court herein is bringing in this provision which wasn't there in CRPC, and the court has not read it in 173 CRPC in the case of Lalita Kumari. But because of legislative overhaul, this one provision is here which is giving the powers in the hand of police officer to, have a preliminary inquiry within the period of 14 days to ascertain whether there is a prima facie case or not. Now, something which Lalita Kumari was trying to curb, this legislative enactment is basically going against that principle. Now, what will be the fate of now this provision is yet to be explored after the implementation of the new BNSS in the criminal jurisprudence of India. So this is for the discussion on Lalita Kumari versus State of UP. For more such videos, stay tuned with us on Legal Darshan. We will be uploading more videos on the AOR exam in the due course of time. Thank you everyone for watching. Please stay tuned. Have a great day.